The Fiji Law Society.
Yes, my lords and lady, the Constitution has provided the framework for the rule of law in Fiji since it came into effect on the 7th of September 2013, the day after it was promulgated. It is the supreme law of Fiji. Pursuant to that Constitution, the Executive has been authorised to administer the laws of Parliament and has done so. Within that framework, this court has been provided with jurisdiction to hear and determine cases about the interpretation of the Constitution, which it has faithfully done in cases. The common law provides the tools. The Fiji Constitution is designed to enable change. Chapter 11 sets out the circumstances in which it can be amended. Chapter 11 does not in form or substance prevent the Constitution from being changed. The Constitution, as it presently stands, expressly provides for it to be amended by a vote of the representatives of the people, and importantly, the people whose rights are governed by the Constitution. We accept that it may be difficult to amend the Constitution, but it is not impossible. The reason why the provisions are such as they are is to protect the higher law, and that has always been reflected in Fijian constitutions. This court has to be very careful of what it's being invited to do. The submissions of the state and some of the interveners invite this court to, in effect, amend the Constitution and remove the requirement for approval from the people and place it only in the hands of members of Parliament based on a simple majority of vote in Parliament. Now, with respect, our submission is that accepting that invitation would be a perversion of judicial power. Courts interpret constitutions, but as a number of your honours have reminded our friends during the course of the hearing, you do not rewrite them. That is not your role. Accepting that invitation draws this court into a controversy which is not within its jurisdiction. That is not the role of this court. Now, my learned friend, of course, for the state, Mr. Walker, was questioned by both Justice Arnold and Justice Young as to whether the effect of the state submissions was that this court should determine that the 2013 Constitution could be amended by a simple majority of Parliament, and if that was so, it would reduce the Constitution to being able to be amended like any other legislative instrument enacted by the Parliament. There's some good exchanges at pages 20 and 21 of the transcript of yesterday, although it does incorrectly refer to Mr. Walker as Dr. Walker. He's been called a great many things, but not Dr. Walker. Now, with respect, rather than answer that question directly, senior counsel for the state skillfully pivoted to informing the court on instructions that if the state was successful in persuading the court that the amendment provisions in Chapter 11 ought be declared invalid, and the court concluded that in order for the 2013 Constitution to be amended, it only required a simple majority of vote in Parliament, the government would nonetheless persist with putting before the Parliament the 2025 bill, which had been the subject of a first and second reading and received less than the required 75% vote. And I'll come back to that on the impossibility argument. Mr. Walker, of course, advanced that submission to this court on instructions. There are two observations to make about that submission. First, it is to be noted that when the matter was last before Parliament, it had only reached a second reading speech stage pursuant to section 160, subsection 2. It had not yet been referred to a committee for a report, nor, of course, had it gone to the third reading speech. In the event the government puts the very same bill before the Parliament, there is no guarantee and there is no evidence at all that the bill in its present form would get through the Parliament in an unchanged manner. Now, the court's being asked to accept the contentions of the state as to how it should construe the amendment provisions, we say rewrite them, based on an indication, and it's completely irrelevant from the government, that it would put a bill before the Parliament requiring a two-third majority vote. Now, my friend on behalf of the state cannot commit the members of Parliament to take the position that they would pursue the two-thirds bill, the 2025 bill in its present form. And all that is going to happen is that by accepting the invitation of the state, and we say to err, the Constitution loses its supremacy. The court cannot determine matters of construction and application based on a promise from the bar table.
Sorry?
Based on a promise from the bar table as to what the court would do, because my friend sought to use that to assuage Your Honour's concerns, Justice Young's concern, when you put it to him directly. Now, second, and this is important to the questions that were asked by the court in the memorandum delivered today, there are no tools of construction available to the court that can convert the submissions of the state into relief that it seeks. That is quite important. Our learned friends, in effect, invite you to pick up the blue pencil and to insert words into the Constitution.
Well, a blue pencil normally removes them.
Well, but they're asking you to go one step further. Your Honour's right, in restraints of trade cases and commercial contract cases. But in the case of a Constitution, what my learned friend is asking the court to do is to excise from it the people. So in order to enhance democracy, we are going to minimise democracy by taking the people out of the vote. And then secondly, what my learned friend is inviting you to do is to reduce it to 2/3. Now, one has got to take a step back and ask the question, what are we doing here in a court of law grappling with such submissions? They are inherently nonsensical. And this court's being invited to go into an area that is political, not judicial. You are being asked, in effect, to trump the views of the people of Fiji.